While Canadians are all living with physical distancing and homeschooling, families who share custody of children are facing a different kind of challenge. Tanya Davies is a family lawyer who's been dealing with many cases like these, and she joins me this morning. Tanya, great to talk to you. This is an important topic. You're hearing about parents who are refusing to abide by their custody arrangements over fear of a greater risk of COVID-19. Under what grounds can a parent withhold custody in times like these?
Good morning, Ben. We actually have a lot of case law that is coming out during these unprecedented times. And we see it in our offices in Ottawa and Toronto, where parents phone and basically state, can I deny access because of COVID-19? And access parents phone as well, saying my access is being unreasonably denied. Again, because a primary residence parent is using denying access or COVID-19 is an excuse. There are a lot of decisions that are coming out because emergency motions are still being heard. And what the courts are telling us is that parenting arrangements should not be disturbed since it is not in the best interest of the children. They can only be disturbed even during these unprecedented times in very exceptional circumstances. So if the access parent is unable or unwilling to practice proper protocols during COVID-19, this is the only reason to suspend access. Anything else, COVID-19 by itself is not a legitimate reason.
All right, so that's definitive. But courts are closed except for emergency orders, as you just said. So what options are open to parents who find their custody is cut off when one of the parents plays the COVID-19 card?
So again, since the courts are open for emergency proceedings, we can represent clients in court at those proceedings. But if the matter cannot proceed to court or it's not found to be urgent, we're still open. We conduct telephone conferences. We conduct mediation sessions by Skype, Zoom. We're accessible by email. And of course, lawyers can negotiate with opposing counsel. So we're still very much accessible to clients.
Okay, so Tanya, here's a hypothetical for you. If both parents agree their children can stay with one of them until the pandemic subsides, is the other parent then entitled to extra child support?
So under normal circumstances, this is how child support works. We'll look at the child's primary living arrangements, and then the access parent, if they're only getting periodic access, would be the payer of child support. There are child support guidelines in place that courts follow religiously. So we look at the number of children, we look at the payer's income, and this is how child support is determined. In that circumstance, the whole amount of child support would be payable. If there is a shared parenting arrangement, it's a set-off amount of child support. So in other words, parent with the higher income would pay the difference compared to the other parent's income. So if all of a sudden this arrangement changes, and the courts are telling us it should not, unless it's an exceptional circumstance. But if it does, technically, the primary residence parent would be entitled to the whole amount of child support. But courts are telling us people need to be flexible. Lawyers need to be flexible in negotiating. So if the payer lost their employment, for example, the primary residence parent needs to understand and maybe negotiate something in between set off and the whole amount pursuant to the guidelines, just to accommodate the best interest of the child and the payer, who certainly would be in a very difficult predicament because of loss of employment, for example, during COVID-19.
Tanya Davies, really great information this morning. Thank you very much, and we hope you stay safe.
Thank you very much, Ben. You too.
Thanks for watching. If you like this, be sure to subscribe here.
And you can check out more Your Morning videos right here.